I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are jumping into compilation number 171, and we have an old friend who is back in court, a sovereign citizen by the name of John Hanna. He's going to be in Judge Phyllis Webster's courtroom. This is a compilation. We are going to share a couple of John Hanna's other appearances, and we have another special appearance as well. But before I give you the rundown on all of that, just know that chapters will be added for your convenience. Commentary from these previous proceedings will be also in this video. Don't forget to like, comment, share, and subscribe. It is much appreciated. And let me give you the rundown on what's happening today in 171. Now, like I said, John Hanna, he has appeared in the state of Kansas in Judge Webster's courtroom twice. So recently he was in her courtroom, and what I'm going to do is normally I would play the older proceedings first and then the new proceeding, but I'm going to play his new proceeding first, then his previous proceeding or previous two proceedings, in Judge Webster's courtroom and Judge Sanders' courtroom. So it's going to be 3 appearances by Mr. John Hanna, but we're going to play his newest one first. And we have a special appearance. I'm not going to tell you who it is, coming out of the state of Michigan in Judge Eran Washington's courtroom, a throwback, another sovereign citizen who we consider our old friend and is definitely popular in the YouTube community. So with that being said, guys, this is number 171. Let's go ahead and jump in.
Okay, any other defense attorneys that have a quick hearing before I start Mr. Patterson's lengthy docket? Okay, gave you a chance. All right.
There's still that pro se gentleman at the jail.
Is that the one sitting there?
I
Mr.
believe
Patterson, is that your client at the jail?
Your Honor, it's not my client. This is the state. That's
Yeah,
I think, believe the pro se defendant.
Yeah, okay. The gentleman at the jail, what's your name, please?
Don Hanna.
Don what?
Hanna.
Oh, are you John Hanna?
Yes.
Okay, Mr. Hanna, do you have an attorney yet?
Yes, I had Charlie O'Hara. I had Charlie O'Hara as a retained attorney. Yeah.
Well, let's go on the record then in BU 2024 CR 420, State of Kansas versus John Raymond Hanna.
Ramon. It's Ramon.
John Ramon Hanna.
Yeah.
Please state your appearances.
Thank you, Your Honor. May it please the court, Joseph Baca appearing for the state of Kansas.
Mr. John Ramon Hanna appears in person from the county jail. Mr. Hanna, you asserted that you had retained who, Charles O'Hara?
Yes. I mean, he's retained every month.
What does that mean? You're paying him every month for something?
Yeah, I just keep him on retainer every month. He's also out of the law offices in Los Angeles as well.
Well, I've known Mr. O'Hara for many years. I did not realize he had an office in Los Angeles. That's news to me, but he certainly is very competent and skilled, so that could be.
And Your Honor.
Mr. Baca.
I'm sorry to interrupt, but I do have some information for the court that I think may help.
Please proceed then.
Your Honor, it's my understanding on this case that at a prior date, a competency evaluation was ordered to be done for the defendant. The state did do some checking into that with the state hospital, and while our notice was sent and the court's notice was sent, it was overlooked by the state hospital, but they are aware of it as of now, so they're going to be getting on top of getting that evaluation done. Now, we're also investigating an issue whether there is a potential federal hold also on Mr. Hanna, but it appears I don't think we can proceed until we get that evaluation.
Can I say something? I'd like to get can I say something, please? I'd like to put a claim notice of reassurance, a claim notice of non-acceptance, and also reaffirmation of the facts, and a claim notice of discontinuance.
What statutory cite do you have for each of those?
I don't have a statutory cite. It comes out of law books.
Well, law books all have
No, I'm
statutory
saying
cite.
what I'm addressing is the claim notice of reassurance and the claim of acceptance is whoever the practitioners of the law, they're actually registered in the Book of Registries in Boston. And I would have my defense attorney put in these claim notices in paper as well. I already got them as oral statements.
First of all, sir, I show that when we were here September 29th of 25, you and Darren Patterson, who had been attorney to represent you, had some issue come up in which he asked to withdraw, and it was granted. He withdrew. I asked you if you wanted another attorney appointed, and you told me you were going to hire your own attorney. So we set this over to allow you to hire your attorney. Where is that attorney? I don't show any attorney has entered his appearance to represent you today.
Because I haven't. I say he's on a retainer fee. He says we have a deal worked out. He's retained.
Well, I'm not sure that he would agree with that, because when he's retained, he shows up and enters an appearance. He sent one of his associates to cover for him in another case today, and that attorney said that they only had that one case and they left. They didn't say anything about representing John Hanna, and they haven't put any notice in file that they're representing you. So it sounds to me like you have not worked out everything you need to with Attorney O'Hara.
I mean, you can say that if you want to, but I would like to address the issue of claim notice of reassurance, claim notice of acceptance, and also claim notice of
Sir, I've been in the legal
non-compliance.
business.
Claim notice of non-compliance.
There is no such thing to my knowledge. No such legal.
I know it's not. That informs me that if you're not according to when you take these law tests, if you don't know what a claim notice of non-acceptance is, that you have to be accepted, you only can take this test 3 times in a lifetime to practice law.
Sir,
So I would like to continue with a claim notice of the proclamation of facts, a proclamation of affirmation of facts, a proclamation of discontinuance, a proclamation of non-compliance for not ensuring me that you're ensuring the bond to do what you're doing, and I like to put a proclamation points of execution.
Sir, there is no such thing in Kansas law. You said you got those out of some Boston law books.
Okay, no, I say Boston law books. I said registry, and the book of registry is in Boston. I didn't say Boston law books. I said the book of registry. And all I asked for the 922G, if you're insured and bonded to do this, because you have to do it according to federal procedure, according to the United States Constitution. If you can't, then there's no jurisdiction, lacks evidence.
All right, Deputy, are you there?
Yes, Your Honor.
So is he on a waiting list for a competency evaluation?
And the state cannot recommend me to a mental hospital. Thomas Bradley, First Kansas.
Your Honor, I'm not aware that he's on a waiting list or anything, but I can tell you that he is currently being housed for the United States Marshal Service.
All right. So, Mr. Baca,
So talk to the Director of U.S. Marshals.
Mr. Baca, you believe that a competency motion was filed or just discussed?
Your Honor, I believe, I'll check the filing cabinet. What I'm looking at to start is the pretrial that we had in September. The notes indicate that the court ordered a competency evaluation on its own motion. The state was to prepare the journal entry on that date. I believe we prepared that. We've also sent that to the state hospital. As I stated earlier, we did check with the state hospital today. While they received everything, it was on them that they had just overlooked that they needed to do this eval. They have notice of it now, though, and are going to be getting on top of it.
So your suggestion in setting this over would be for what type of hearing?
Your Honor, I do believe if we could set it over for a status just to check for the competency evaluation, take it very likely off the jury trial docket, that would be my recommendation. I think probably nothing less than 60 days, knowing how the state hospitals have their time in the past in getting those done.
I just took a competency evaluation at Butner. And when I went to Butner, you raised my bond for me being transferred to Butner. They raised my bond when you transported me somewhere. Raised my bond when I was in Butner and came back, and you raised my bond on that. I was found competent. And I did very well on the test. Like I said, this is insulting my intelligence, man. It really is because like I said, you haven't addressed the non. If you saying the 920, I asked for your 922. If you're reinsured and bonded, and I asked Your Honor as well if you have a 922 reinsured and bonded, and you never addressed the issue. So I'm putting a proclamation notion of discontinuance for this. I don't. But I guess the third time I've said this.
Well, sir, I think I need to do a couple of things. I need to make sure you get that competence evaluation, and I'm going to continue with that order.
You can't
And
do it.
I want to reappoint an attorney to you because you told me you were going to hire your own and you didn't. You told me today you have, but I don't believe you have. From what I've seen out of the office you said you hired from. But first order of business, when can we do, Jen, a competency evaluation about at least 60 days out?
You take all money from me.
Your Honor, you do have an opening May 11th.
At 9 o'clock?
Yes.
All right, let's do May 11th at 9 a.m. in order that he be brought back or that he reappear May 11th at 9 a.m. on that, follow up with that competency evaluation. And when he gets back, well, I can't appoint our public defender contractor because
You're not addressing the issues. Definitely. She's supposed to address the issues. Thank you.
Jen, do you think that normally I would turn to Mr. Josh. I turned to Josh, but I don't think he's taking those anymore. I think he's got other responsibilities. I don't know if Cooper's would be able to fit one in, but I would like to reappoint. We don't have a list for misdemeanors like we do felons, right?
In the past, Josh cannot take any more appointments.
That's what I thought. Yeah, I used to.
Before.
Say that again, please, that last sentence.
You have appointed William McClendon before, or Chris Pate.
Try William McClendon. I don't want to burn him out on it, but yeah, let's try William McClendon again. Or you said Pate. If Pate would take, you might want to try Pate first, just because of the experience factor and nothing more. I think Mr. McClendon can handle it, but like I said, I don't want to I think anyway, saying less than more, either one of those two would be fine. And we'll set this over, Mr. Baca, to May 11 at 9 a.m. to reevaluate that competency or to review it.
Thank you, Your Honor.
You're welcome. And hopefully, now that you've got the state hospital's attention, busy as they are, they'll make room like they told you they would. So, all right, Deputy, thank you for bringing him out. He's remanded to your custody, to the sheriff's custody.
Are you Mr. Hanna?
Yeah.
All right. This is case number 2024 CR 420, State of Kansas versus John Hanna. Mr. Hanna, it looks like you've been charged with one count of sexual battery. That is that's a Class A misdemeanor. That can carry up to a year in the county jail and a fine of up to $2,500. So let's talk about how you might want to handle your case. This is just the time just to let you know what your charges are. Did you get a copy of the charges against you?
Of course not. I haven't even been found guilty on the sanction, the write-up while I'm in here.
Well, of course you're not going to be found guilty yet.
But I mean, I don't mean to interrupt you, but that's the procedure. And I mean, we could talk to the Department of Justice about the jurisdiction of the case as well. We can take it to that extent, but you can go ahead and continue. I would like to challenge the jurisdiction on the charge. I want to state that for the records as well. Will you continue? My apology.
Mr. Hanna, I'm going to run this court, not you. And you can start off with the sovereign citizen crap about jurisdiction and everything else if you want to.
I'm saying, I understand that. I'm just saying, but
it's not going to
you
get
talk to
you.
the Department of Justice as well, because you know who the director of the Department of Justice is, right?
That's just fine. You can do whatever you want.
We'll between now.
Anyway,
He'll be waiting on an indictment on you.
In any event, you're charged with one count of a sexual battery, Class A misdemeanor. Are you going to have an attorney to represent you, or do you want the court to appoint somebody to represent you?
You can appoint me one, and I'll have an attorney later on when I find one.
Okay, I'm going to go ahead and give you a hearing date on the misdemeanor control docket. Your next hearing is going to be November 18th at 9 o'clock with Judge Webster. That can be by Zoom. Mr. Canfield, what's the state's recommendation on bond here?
Your Honor, in addition to the sexual battery against a deputy, the defendant also has been convicted of aggravated domestic battery, aggravated battery, and aggravated escape from custody. So at this time, the state's recommendation will be a $7,500 cash or surety bond.
Those charges aren't even my record. For legal detainment,
very well. The court's going to go ahead and set your bond at $7,500 cash security.
Maybe facing the grand jury.
If you can, sounds like you can afford your own counsel, so I'll let you go ahead and see about doing that. If you can't afford it, when you get around to your next hearing, you can ask the judge to appoint counsel for you. But I've given you your next hearing date. You know what your bond is. You'll need to stay with the sheriff until such time as you are able to execute your bond.
And so we didn't address the jurisdiction issue either, right?
The fact that you're where you are and I'm where I am means that I have jurisdiction over you.
They show one on John Hannah. Is that what you show?
Mr. Hammond.
I'm sorry, Judge, I didn't hear you.
You have just one case on John Hannah today?
Yes, Judge. Yes, Judge, just one case.
We are on the record in 2024 CR 420, State of Kansas versus John Raymond Hannah. Please announce appearances.
Jerry here on behalf of the state.
Your Honor, Darren Patterson, here on behalf of John Hannah. Mr. Hannah does appear via Zoom audio visual from the Butler County Jail. Judge, this is a case where I am requesting the court to allow me to withdraw. I would just tell the court that communication has broken down to the point where counsel and client are not able to discuss the case any further and would ask substitute counsel be appointed, or Mr. Hannah may hire counsel. I don't know.
Mr. Hannah, are you able to hire counsel?
I'll have to look into it, but I'm pretty sure I can figure something out.
Well, if you can hire an attorney, you should hire your own attorney. But you apparently told me or someone else that you couldn't afford an attorney early on, and you received court appointed.
No, I was saying that I have been in court. I've been pretty much in a situation where I was supposedly incarcerated to where I haven't been able to contact my family members. What I explained. That's how I explained that. I don't like contacting my family members from facilities like this. Because I had problems stealing my mail and identity theft, so I really don't condone talking to my family member and giving out addresses in a situation like this with these people that don't have what they call a 922E or a 912E jurisdiction. So we can continue on if you want to try to. I just adjust jurisdiction right now.
Well, what in the world is a 912E jurisdiction?
I'm the judge. You're supposed to figure it out. I'm telling you for. You a judge?
Well, guys, as you can see, Judge Webster is a little thrown off by this whole 912E jurisdiction thing. I am as well, because it's my first time hearing it. But FYI for you guys, it doesn't even have anything to do with anything in the United States or dealing with the United States. Is actually something that deals with the Australian Corporation Act 2001. So it doesn't even have anything to do with anything here in the United States. But yet here it is. Mr. Hanna is quoting it.
I can't figure out something that doesn't exist.
It does exist, but I'm saying if you don't exist, I understand. If you don't know, I mean, it's not my fault.
Well, it is. If you're going to bring something up that I'm not familiar with, you're going to have to tell me what it is.
No, it's jurisdiction. I mean, you supposed to look it up. Everything you hired a counsel for me. You hired a counsel for me, and this dude is over here like supposed to be the. I mean, and then and the other thing, dude told me that the court that he said it was going to be 3 days from now. He didn't say it was going to be today.
Who told you that?
He did. The attorney did.
All right. Mr. Regier, do you know what this, tell me that number again. What is that number you're citing, sir, for jurisdiction?
922E.
920.
And you got a 912E too.
And a 912.
Yeah, that establishes that the corporate courts are illegal in the United States, pretty much.
Corporate courts are illegal?
Pretty much illegal in the United States, yeah. Pretty much.
Okay, that's
on the Brady violation as well. Maryland versus Brady.
I know Brady.
Yeah, Maryland versus Brady, yeah. And when we addressed this issue, you should have started with Maryland versus Brady. When you addressed me before anything, you're supposed to address me with Maryland versus Brady.
All right, stop it. Stop it right now. I'm not going to keep taking your abuse.
Okay, I'm not going to take abuse. I'm going to lock those handcuffs on.
All right, you're going to stop it. You're going to sit him down, and you're going to show respect for the court. You have
it's my house.
Stop it right now.
My house. I built it, whatever. I built it. I'll pay down this bill.
You will stop it right now. I understand we have a screen between us.
Yeah, okay. I know we have a screen between us. I don't even know if you're in the courtroom, for real. Let's do a video.
Well, I think I understand why Mr. Patterson, a very experienced, very competent, qualified attorney, can't work with you.
I got a couple of them too.
Well, if you got them and you can afford them, there's no reason the taxpayers ought to be paying for your attorney.
No, I'll pay. What do you mean? The taxpayers ain't paying for my attorney. Point blank. Quit telling my intelligence, please.
Well, I'd order them to take you into custody, but you're already there.
I know I'm in custody, and you went up on my bond in custody. How do you do that? Oh, that's what Department of Justice right there. Thank you. Are there any more things to issue, Mr. Jay? What's the prosecutor's name?
You address me. You're stop it. Mr. Patterson, you are most definitely excused from this case for the reasons cited. You may journalize the dismissal.
Yes, Judge.
And I don't see any need to point anyone else because the defendant's telling me he can afford an attorney. You just need, what do you need to hire your attorney?
Let me figure it out and I'll get to it. I don't like to make rush decisions, especially in handcuffs.
All right, Mr. Regier, have you ever heard of this?
Thank you.
What he's talking about?
Him too.
Stop talking. Do you, Mr. Regier? Mr. Regier, do you know what he's in reference to when he says 922E jurisdiction and 912E jurisdiction?
I wrote that down backwards.
Judge, I think those are pursuant to federal rules of procedure.
Well, we're not in federal court, so I don't keep
But you have to go by my constitutional rights for a due process. For to be a corporate court, because you're financed by federal money. This is not financed by the people here in this county. You get government grants to run this place from the feds.
Where in the world did you hear that?
It's the truth.
Where'd you hear it?
I don't matter where I heard it because I do my own research. I'm not answering that question. I would plead the fifth on that question.
Well, I don't know what he's talking about. Exactly. It's a federal rule, but this is not.
So we can bring up the competency of the court right now. We'll have to turn just on that. Do we need any issues, Mr. Prosecutor? The Department of Justice going to be emailing you pretty soon.
Sir, let me explain something to you. You are in the district court, 13th Judicial District.
For misdemeanor accusation.
State of Kansas. This is not federal court.
I said federal court.
The rules that apply are the Kansas statutes annotated, Yes, the Constitution applies, but you're not citing Constitution. You're citing apparently federal rules of evidence that apply in federal courts, not in
No,
Kansas.
that doesn't apply in federal court. It applies to a state because it goes with Maryland versus Brady.
Where did you get your law degree?
You don't have to have a law degree. Doesn't matter about that because I've been educated by the best attorneys in the United States. One of them is I happen to be real close to one of their daughters, a few of them, and their sons, and their sons. And I personally know a U.S. Supreme Court judge as well.
All right, so Mr. Patterson is allowed to withdraw, and that's at your request, Mr. Hanna. You want him off your case, right?
Definitely.
All right, so this time is going to count against you so that you can get a new attorney. And you told me you are going to hire your attorney. Is that right?
Yeah, I said I will figure it out. Is what I said.
All right, so you'll figure it out. You don't want the court to address another court appointed, right?
Pretty much not. Not with that competency level.
Not a court appointed attorney. So let's have the notes reflect. He does not want a court appointed attorney. He questions the competency level.
I'm going to go after the prosecutor now.
Oh, you want to go? You said you want to go
against prosecuting. Thank you. Say put that on the record. Tarik got on paper. Thank you, Mr. Prosecutor.
So what did you say? You want to go after the prosecutor?
No, I said we will holler at the Department of Justice. We'll talk to him. Go after his accusation is what I said. Confront his accusation with the Department of Justice. That's what I said. Thank you. Is there anything else so I can get back to where I was legally incarcerated at?
Deputy, do you think that does he normally behave competently? I'm wondering if I need to do a competency evaluation. Anyone want to be heard on that?
I've already had one.
In this case, you have?
No, I have one on my federal case. I felt competent because everything I stated with it is already backed by law.
Well, I am going to, on my own motion, order that there be a competency evaluation. That can be done in the county jail because I'm not sure you're tracking, Mr. Hanna.
Good for you. I don't care if you think that or not because I can decline it. I can decline that. And if I'm found incompetent, that means you can't do what? You can't put me in a court of law. So you just made another mistake.
Well, if you're found to be incompetent, you will go to a state security hospital.
No, I'm on it. You can't legally commit me to a hospital?
Yeah, I can.
No, you can't.
There, yes.
No, you can't. That just goes to show you try to commit me to a that's illegal. You can't do that either.
Well, he's set for jury trial this week. I'm going to continue the jury trial because he needs a new attorney. The time will count against him.
So how to do illegal commits, take people's property, identity theft. Yes.
And we need to do a competency evaluation. We will set this over. When's my next available jury trial date, Jen?
February 23rd for the pretrial, February 25th and 26th for the jury trial.
You said 26th, and did you say 25 and 26?
That's correct, Your Honor.
Okay. All right. So the defendant is ordered to be here February 23rd for pretrial and February 25th and 26th in person for a jury trial. And then when I get the motion on file for competency, then we'll set the competency hearing before then, of course. I see you have had a U.S. Marshal hold on federal charges. That was back in April of last year. I see there was a previous failure to appear.
I was in Butner on evaluation because I had to get rid of the last attorney I had. His name he was going under a fake name. His name was Kurt Burrows, and his name was Beeman-Howard. So I had to remove from my case because he wasn't even who he said he was.
Well, I don't know.
Party mistake. Yes, conflict of interest. Yeah, I've had to remove from the case.
Well, I don't know either of those names. That must be on your felony charges.
Yeah, felon possession firearm, which I got a settlement on. Then I got a settlement when I was in federal prison for it. Got a settlement for it. I've been illegally detained. It's in the point. It's in the law book.
And I see your first appearance,
crazy, man.
9/6 of 24th. You were found to the court at that time. I think that might have been Judge Satterfield. I'm not sure. Found you very combative and challenging jurisdiction even then. Oh, it was Judge Sanders. That was retired former Chief Judge Sanders. Okay, former Chief Judge Sanders. All right. Well, I think everything is resolved. Anything else, Mr. Regier or Mr. Patterson, we need to address on this matter?
Your Honor, more of a point of clarification. If the court is ordering a competency evaluation, the state will be requesting clarification as to who has prepared the appropriate journal entry.
If your staff has those forms available and wants to do that, that would be fine. If not, I'll have to do it myself.
Very good, Your Honor.
And Judge, I'm out of the case, of course, but I think Mr. Regier knows that it's supposed to be the local mental health department that does the initial evaluation.
Yes.
The state is well aware of that, Your Honor.
Thank you.
Can't do it because there's conflict of interest. He doesn't want interest.
Where's the conflict of interest, sir?
The prosecutor cannot give me he cannot be the one that gives me a competency hearing because he doesn't have my he's the one that is he's the one accusing me of something. He's the one that brought up the charge, so he can't be the one in charge of my mental competency hearing because it's a conflict of interest. It has to be somebody who has my interest.
Well, I don't have your
or somebody that's objective to it. Objective point of view, it can't be him.
Okay, well, I'm the one that is ordering the competency evaluation. He just has the staff to do the paperwork, but I'm the one ordering it. And Deputy, please, I'm remanding him back to your custody, the custody of the sheriff, to take him back wherever you need to take him.
Thank you, Your Honor.
You're welcome.
Well, guys, we've come to the end of both of these proceedings for Mr. John Raymond Hanna. And as you can see, he definitely is a handful. He definitely loves to talk out of term. Sometimes he's talking so fast, it's kind of hard to understand what he's saying. And you notice when Judge Webster told him she didn't understand something he was saying, he kind of felt like that was a victory for him. Like, like he got a win, like it was a W for him. But nonetheless, because of the way he's talking fast, talking over, she's ordered this competency hearing for him, which he says he's already done and that he's already passed. But something he did say in there that was true is that if he is found incompetent, then that means he wouldn't be able to go to any more of these proceedings. And then she explains to him, well, you're going to have to go to a facility and so on and so forth. But we're going to try to keep up with this case. Mr. Hanna is definitely going to be an interesting individual, especially in a trial, to probably watch him go through a whole full trial. It would definitely be some wild and crazy moments, and we'll probably hear some wild and crazy things that we never heard, because even the other statute that he was quoting, I had never heard of that as well. I believe he said 922D, and not saying that it isn't an actual a statute or deals with the law, but more than likely it's just going to be like 912E. Is going to be something that's taken out of context. But as always, guys, I appreciate you joining me here at Sovereign Citizens Hall of Fame. Don't forget, once again, to like, share, subscribe, and comment. Your feedback is important. And listen, nothing else to be said, but for now, guys, Sovereign Citizens Court is adjourned. I'll see you guys on the next video. God bless.
Country Meadows versus Tarik Samar Day and Erica Witherspoon. Case number 23C0276.
Christopher Borkin for the plaintiff.
Tarik Samar Tarik Day.
Thank you. Mr. Day, did you serve this notice to principal? Is notice to agent, is notice to principal, administrative procedure motion that you filed with Mr. Borkin?
It was a.
Sir, my question was simple. Did you file it with Mr. Borkin?
I don't believe so.
You have to file anything you file with this court with Mr. Borkin and opposing counsel, or is considered not filed. That's the court rule for any court.
Oh, okay. I must have missed that.
So he filed something called affidavit of high prerogative writ of quo
pro warranto. Yes, ma'am.
It's not something that gets filed in the district court anyway, but he did file that, and I presume he's going to file that with you.
Thank you, Your Honor.
I will do that.
Your Honor, my client is here to chime in. If it's necessary to take testimony.
I'm not even sure what this document is. He is filing something here that he wants a fraud of false claims for $30,000, conspiracy $250,000, failure to respond $1 million, failure to respond as outlined $1 million, summons to the court, which you can't do. I'm not even sure what any of that means. Responsive communications $250 a page, and then $2,313,500 for review and research of responsive communications at $500 an hour, but he says it's 8 hours.
The property was put into trust as a trust property, and the subject matter of the trust is the subject matter of this case is under the trust. The case number, account number has been conveyed to trust as well, and I was seeking to have this matter handled with equity.
Mr. Day, I'm seriously becoming very concerned about your mental capacities, which is a very unique situation to have to deal with in a civil case.
I'm not sure what to say to that. Ultimately, if just seeking for the plaintiff to provide that the original negotiable instrument wasn't securitized, because if it was invested or securitized, it means that it should be discharged.
Mr. Borkin, do you have a response to whatever?
I would focus on the complaint that we filed, which was for non-payment of rent. I would indicate that there's still an amount of rent owed to date.
Mr. Borkin, I fully understand that. However, at this point in time, the court just indicated that I have some concerns about his mental capacity as to whether or not he should be trying to represent himself in a court of law at this time, because I don't think that he fully understands what's happening here today. So I'm not going to proceed unless I feel like he fully understands what's happening, which is a problem.
Your Honor, I believe there's another defendant on the complaint. I don't know if they're present today.
Is Miss Erica Weatherspoon present with you?
No, she's not. She's currently 9 months pregnant.
All right. First of all, Mr. Borkin, I'm not willing to move forward on this today. I have to do several things. One is I want him to file with you the motion that he filed with this court. So that needs to go to you. Two, I need to research how to do a referral in a civil case. If that can be done in a landlord-tenant case so that he fully understands what's happening, because I don't think he understands the proceedings that are going on right now. And then three, I'm going to refer him to speak with someone at legal services so that I can at least feel like he's had that ability to communicate with someone. If he doesn't do that, then that's a whole separate subject, because then maybe I can at least justify moving forward with where we are right now. But at this point, I am not comfortable moving forward.
Your Honor, I would provide my email address, and he could send his motion to my email if that's easier.
Thank you. Mr. Day, are you able to?
Yes, ma'am.
Are you able to determine? Are you able to see what's in the chat feature, sir?
I think.
Do you know how to get to chat?
No, ma'am. I'm sorry.
Right. What you're gonna need to do is look on your phone. Do you see 3 dots at the top of your phone that say more?
I'm currently on a laptop.
Oh, okay. So look at the bottom of your
Okay.
screen. You see it where it says chat? You see something in red at the bottom that says 32 or 33?
I do see chat.
All right, click on that and you should see his contact information in there. You need to file this notice, motion, whatever you call it, with him. Okay, so that's first step. 2, you need to I'm referring you over to legal services so that you can talk to them about the nature of these proceedings so that you fully understand them. Okay?
Okay.
And that is they have hours between 10 and 11:30 on Tuesdays, and then 2 and 3:30 on Thursday. Okay?
Okay.
And then I believe the last thing I said was once you've served them with that motion, I'm going to look into whether or not there's the ability to refer for competency, and I'll have that answer when we come back here next week. I'm going to adjourn it over for 1 week to see where we are with all of this.
Am I not able to ask for a jury trial? Is that a different process?
You can ask for a jury trial. There'll also be an escrow where you have to put your money in escrow until that time comes.
Oh, okay. Is that escrow? Is that is that something that you all provide?
You have to come to the court and put your money into play it here at the courthouse, sir.
Okay.
And you have to file the proper demand for a jury trial. That's probably why you need legal counsel.
Okay.
Okay. So how much is the rent per month?
Are you asking me, ma'am?
No, I'm asking Mr. Borkin.
Okay. Sorry.
My complaint indicates that monthly rent is $1,083.
$1,083. So that's how much you'll need to be placing in the escrow until the trial happens, okay, sir?
Okay. Is because I think my partner, she completed something with Michigan Bridges to maybe get some kind of extension or help or something financially.
That may be true, but if you request a jury trial, you have to put your money in escrow. If you don't, then you waive your right to that jury trial.
Okay.
Okay. That's why I'm telling you to go over and talk to legal services.
Yes, ma'am. Yep.
All right, so I'm going to bring you all back here on March 15th. You need to serve him with that document, okay?
Yep. Yes.
And then I'll see you here on March 15th. I'm going to schedule this at 3:30.
3:30.
Okay?
Thank you, Your Honor.
You're welcome.
Okay, thank you.
You're welcome.
Well, guys, we have come to the end of this first proceeding. And if you know anything about Tarik Day, he definitely is being himself. He has not changed. As we can see, him asking for almost, when you kind of calculate it all together, almost $5 million for what I don't know. We see that he sent in an affidavit, and I had to write this down. I could not remember this off of the top of my head, but the affidavit of high prerogative rid of pro quo pro Warren Co. And obviously only he and whoever he's getting this literature from knows what that is, but nobody in the court knew what that was. And as we can see with Judge Washington, she felt like, listen, and one thing I like about Judge Washington, I think she's a very sincere lady. I know sometimes we want to see these judges come down hard on these guys and just put them away, lock them up forever. But she has that mother type heart, like that Karen type heart. And I think you need to have some of that as well as a judge. And what we see is she is very concerned about his mental capacity and if she should be moving forward in this particular case. So as I told you before, the case has been, it was, I should say, because it's an older case, but it was continued, and we will be sharing that next proceeding in our next video. And then after that, there will also be a trial. So you guys don't want to miss any of those videos. But for now, we're going to get ready to check out of here. I appreciate you guys always tuning in. Don't forget to subscribe, like, and share. You guys have been amazing thus far. With that being said, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. I'll catch you guys in the next video. God bless and peace.
I'm not threatening you. Say one more word and that's 30 days. 30 days.